Hey, Sal.
Hank, what's going on? We haven't worked a case in years.
I just bought my car at Carvana, and it was so easy. Too easy.
Think something's up?
You tell me. They got thousands of options. Found a great car at a great price. And it got delivered the next day.
It sounds like Carvana just makes it easy to buy your car, Hank.
Yeah, you're right. Case closed.
Buy your car today on
Carvana.
Delivery fees may apply.
Welcome back, everyone, to Real Estate, Real and Unscripted with Nicole. I am very excited to have you back here with me today for an awesome show that we have. And as you know, I'm very passionate about certain things, and one of which is the world of probate. Probate affects real estate in so many different ways, and I am a realtor that focuses in the probate space. I do a lot of probate listings every year. And I feel like there is a lot of things that people don't know, a lot of misconceptions. And so it's a very, very important topic. As you know, I'm very big on planning, making sure you get your ducks in a row. And what we're going to talk about today with a good friend of mine and amazing attorney, Nicole Loughlin, who is a probate and estate planning attorney, is basically all of those things that what happens to, what can you do to prevent this? And what happens if you didn't prevent this? And what does that look like? So I am excited to have her on. I would love to, for you to share with our listeners out there a little bit more about yourself. What brought you into this space? Were you doing anything else, any other practice of law beforehand, or were you always in this world? What drove you into this, and what do you love about what you do?
Well, thank you so much for having me on, Nicole. I'm really excited to talk to you. You are an expert in this area. I know you could probably run a probate yourself, start to finish, with how many you've done over the years. But I'm also passionate about probate. My law firm is Loughlin Law PA. It's a boutique firm located in Boca Raton. We practice throughout the state, and we focus on probate and estate planning and personal injury work. And to answer your question on, what led me here, prior firm that I worked at, I did a lot of personal injury work. And I love that work, but I sort of transitioned my practice more to probate. And with that, I work with a lot of personal injury attorneys on their probate matters, especially when they have wrongful death claims or plaintiffs who have passed away. And so I was able to sort of dovetail those practice areas really nicely. And then, of course, on the planning side, we're helping people prevent some of the issues that we see come up on the probate side. And I'm very passionate about working with families and giving them peace of mind, especially young families with minor children who really need to make sure that they have a plan in place for their kids.
Yeah, no, very, very important stuff. And on another show, we were talking about the role of guardianship in what ends up happening when your child is 18 and you don't have the right paperwork, and God forbid your kid ends up in a hospital and they won't talk to you, right? So people usually think of all this planning as, I'm old, I need to have a will, I need to know what happens when I die, and but it's to be done way, way before that. And there's so many things that can come about that if you don't plan properly, you don't have to be older. It's not just what people think is that I have to do a will as I'm getting older. So I'm very big on the planning, and you do a great job when it comes to that, and super thorough and very proactive on things. And so definitely excited to, talk to you more about this. So probate, what is probate? What, for listeners out there, what exactly does that mean? How do you get in that place? And tell us a little bit more about that.
A lot of times when I'm talking to people about this, I'm like, what is probate and why should you care about it?
Yep.
Right? Because most people are like, that's something that happens after I'm dead and gone, and somebody's going to have to deal with it, but it's not going to be me. And that's not really the mentality that we want to have, especially if you care about the people who are going to have to come in and clean up a mess. You really want to make it as easy as possible for them. Again, on the planning side, we focus on probate avoidance, but we can't always avoid probate. And I have a very robust probate practice, and Probate occurs when somebody dies owning assets in their name alone. That means they didn't own it jointly with someone else with rights of survivorship. They didn't have beneficiary designations. They didn't have it in a trust. They simply owned it in their name. And what happens when somebody passes away is anything that was in their name becomes the estate of. And so on the real estate side, you'll notice, or we'll notice, your sellers will notice that, hey, all of a sudden the property appraiser changed the ownership of the property to the estate of, and I haven't opened up a probate yet. Did somebody else do it? What's going on? And it's just the designation, right? There is no more. The decedent is gone, and so now everything is owned by this fiction of their estate.
And that comes from like the vital records, like they all talk to each other. And on public record, you'll see it says EST. So when someone, and as fellow realtors, and I bring this up because I've dealt with many agents over the years, and even recently where I was going to show a property and I pulled up the VCPA because I wanted to verify the size or whatever it was, and I looked at the name on the BCPA and I'm like, oh, good Lord, EST. Okay, I'm not afraid of probate. Everyone's afraid of probate too. They freak out, and I will tell them, listen, I've done this multiple times. We're good. I know the timelines. This is no. It takes 20 months. No, usually not. And this is where we're at. But I looked at that and I said, okay, let me look at the listing description and see if there's broker remarks about the probate. When there is probate, when you're selling it within the probate time frame, there's certain verbiage the attorney gives me to put in there that, subject to the court approval, blah, blah, blah. But there was no mention about anything about this property being in probate. And I reached out to the agent and I was like, hey, quick question. I see that the listing BCPA says EST. What's going on with the probate? And before I even messaged them, I went into the Broward court records and I found the probate. And I looked at the docket, and I've done this. I'm not an attorney. I'm not giving legal advice. I'm looking at it from my opinion. I've seen it. I know what to look for from working with you and everyone over all the years. And nothing was done to this file since 2022. It just been chilling there. It didn't have all the stuff that we look for that I know when it gets to that point. When you tell me it's there, it goes to and I was like, okay. And then I reached out, and the agent basically said, what probate? What do you mean? And I was like, oh, good God. Okay. Mind you, this property was listed for like 6-7 months. And then can you imagine at that point when you finally have someone who, a live buyer that's interested, and then they bite, and then you're like, oh, whoops, we have a problem, right? So I asked the agent what happened. I said, oh, really? Okay. Who signed your listing agreement? And they said, the daughter who's the executor of the estate. I'm like, all right, wonderful. And I corroborated the name on the court record. I was like, okay, she's there. I'm like, but what's up with the probate of the property? There, nothing's been touched since 2022. She's like, oh, I was told that everything was good. I was like, not for anything. You might want to follow up on that. And it was a problem. It was not done. Something happened. They didn't follow up. The attorney, and they thought that things were done. You never know, right? So, yeah, as far as, when it comes to agents, when we're seeing that EST, what does that mean? What are you doing next? Are you, if you're not familiar with probates, if you haven't worked them like some agents do, like we have, you need to definitely reach out to that probate attorney, speak to the seller, whoever reached out to you, right? The daughter, whatever it might be, and have a conversation and say, hey, can I connect with the probate attorney so that you know what's going on, right? We need to connect. If it's not you that's on the probate, I speak to that attorney and they'll tell us, all right, this is where we're at. These are the timelines. We're going to sell it through, within the probate. We're not going to do order determining homestead because it wasn't their homestead. It was an investment property. We're going to get court approval. You need to put this verbiage on the contract. Those are all things that as the agent, we have to make sure that we partner with. So, as far as agents out there, when you do come across that, if you have any questions, reach out and make sure that the right person's actually signing your documents, because I've had many people over the years. I had one, and I'll never forget. She was angry at me, and she was like, I'm the only daughter, so I own the property. And I said, ma'am, with all due respect, you don't right now. Your property, the way the last deed was done, is literally just in your name, and now the public record says EST. And so we're going to need to get it probated. If you want me to give you a recommendation to someone to give you more information, but from my perspective as a listing agent, who's signing? No one's signing. I can't sign to the person that's on the deed. That the last on the deed is no longer with us, right? So, that's something a lot of people don't know. They don't realize that. Do you see that come up a lot too, where people don't think that there's this process after?
So there's a lot of people putting blinders on during this process and waiting for somebody to tell them, hold on, you can't move forward, right? And they're just sort of like, how far can I take this before somebody's going to stop me? But that's the wrong approach, because you're right. Like, it should not be scary if you see there's an EST. I'm an agent, right? I don't list. It's one of the tools in my toolbox that I have for clients to be able to help them through the process. And I always tell other agents, when you see that come up, before you have this new potential listing and you see it's EST, before you get on the phone with your client and you start telling them things that you're not sure about, and you start making promises, you call somebody who knows what they're talking about and get some strategy, right? That doesn't mean that it's going to result in a referral, right? Like, you have a question, you call me because you want to, get some information. That doesn't mean that there's a referral attached to it. You know what I'm saying? You need to be educated so that you can talk to your client and not overpromise, something that is just totally out of your control. So I created a guide actually for realtors for that, to say, these are the different types of probate. This is what you need to have in your agreement. These are the potential roadblocks, so that nobody is saying, in realtor, in the realtor world, you can move a transaction along, right? You can move a transaction along because you can pick up the phone and you can nudge people and you can, get people moving, but you can't do that in probate, right? You can't pick up the phone and call the judge and say, we need to close, we need to close this house. So you need to have some strategy, and the tactics that you might use on a typical transaction are not going to work on a probate. But having said that, like I said, the EST on the file doesn't mean don't take the case. It's going to be, a pain. Definitely some of them are, we've lived through that.
We've done, yeah.
For the most part, we could talk about the horror stories, but for the most part, it's not that scary, right? It's one of two things. It was either the person's homestead or it wasn't. And if it was the person's homestead, you may be looking at a really smooth transaction because it's an exempt property and it's going to pass seamlessly.
And maybe the estate wasn't so large. They didn't have a lot going on, right? That's their only property they had sometimes. Yeah.
Yeah. You could open it and in theory, you could open it and you can close it, and it's not a big deal. In the case that you were talking about, where nothing had happened for 3 years, in that case, you could probably clean that up pretty easily and convert it to a summary administration, because it's been more than 2 years since the date of death. All the creditor claims are barred. So in a case like that, I mean, I don't even though I don't like taking over files from somebody else that maybe didn't, make some moves on it. Nobody likes to clean up somebody else's mess. But having said that, that's a relatively easy thing to do. Pick it up, convert it, get your order, and then your seller's no longer the estate. Your seller becomes your seller is the heir, whoever inherited the property, the beneficiary of the heir.
Right.
Yeah.
So, does a will avoid probate? People think they got their will. What ducks and docks of ducks do you need to have in order, and is a will sufficient?
The biggest misconception, I would say, is that people believe if they have a will, they've covered everything. I've had people come to me with multi-million-dollar real estate portfolios and ask me to do a will, right? A will does not keep you out of probate.
It gives the court the roadmap of where to take you when you are in probate.
It's correct. The will is made to be deposited with the court so that the judge can oversee the administrative process and ensure that the will is carried out. The terms of the will are carried out. So a will allows you to name your personal representative of the estate. That's the person who's in charge of wrapping up your affairs legally when you're gone. They'll have the authority to access the estate assets, to notify creditors, notify interested parties, make distributions, basically handle all the business of the estate. Your will states who inherits your assets. Right? Now, if you have beneficiary designations on your retirement accounts, your life insurance, your brokerage, whatever, that's not going to go through probate, right? Beneficiary designations are going to keep you out of probate. But if you own a piece of real estate in your name alone, that's an estate asset. So the will state who gets that property. Now, there's some pitfalls with creating a will. If you create a will on your own, or you create a will with somebody who is maybe just doing this as like an add-on to their regular practice and they're not really practicing in estate planning, there are some things to look out for, right? There are restrictions on what you can do with your homestead property, right? You cannot just freely devise your homestead property if you fall into certain categories. And doing that, I've had cases where people will, in their will, direct that their homestead be sold and that the proceeds be split between various parties. Well, that direction to sell the homestead eliminates creditor protection. So under normal circumstances, the homestead would pass directly to the heirs and pretty seamless. As you know, pretty seamless transition, right? You still need to petition the court, but it's not the end of the world and it's fairly simple to do. But when you put that one little sentence in a will, and if you're a practitioner that doesn't practice in this area and you're just listening to your client and you say, okay, that makes sense. You want to sell the property and you want the proceeds to be split like this. What you don't realize is that now you've opened up the homestead property to creditor claims. If you had an illness, and your last illness prior to death, and you owe the hospital $500,000, the homestead's fair game.
Ooh.
Right? So that one little sentence could alter, that entire situation. So you have to be really careful when you do a will, and you also have to know that the will doesn't keep you out of probate.
No, for sure. Yeah, those are really important things. And as you know, I'm very big on like stay in your lane, focus, and be an expert. That's kind of how I built my business over the years. And people would say, oh, do you do commercial? No, I don't. And I'm not going to pretend like I do. Like, I like to stay in your lane. And I like to see when professionals are like ultra focused, and because that's how you know you're getting the person who's going to cover all those bases. Because if you're not doing something, especially like agents, if you're not doing it and selling lots of homes and getting all that experience and seeing all those options, you're going to miss things. And things like that are very important, and people don't realize, because there's a lot of mistakes out there. There's a lot of mistakes out there. And I can tell you just from my own career in 10 years and doing this probably 6-7 years heavily in probate, I've had so many mistakes and people don't realize what they did. And so one thing too, I'm going to just mention as I'm thinking about it, like planning, right? So how do you avoid your property from going into probate? What are the different options? And then in that case, as well, as you talk about those different options, the importance, everyone listening, of working with an attorney to do these instruments, right? Because, funny story, I had a seller that I literally had to sit with my broker, who's an attorney, and spreadsheet with like this one went here and that one went here. And then the next deed, this is how it went, because it was so complicated. They did deeds themselves, and there were like 12 transfers over a bunch of years. And we had to there was a point where it got hairy, because I was like, she didn't get deeded out. When did she die? And then I had to get the date. And then we were like, okay, great. She passed away before, whatever it was. I can't remember. And we literally had to right? So I think a lot of people do themselves a disservice thinking that they could pull up a will, or they could pull up a trust, or they could pull up a power of attorney off the internet, and it help. But
so one of the biggest things I see, and it affects people during their lifetime, right? A lot of the times people won't ever see their mistake until it's too late, because these documents are not going to be offered up for analysis until somebody passes away. But one of the things that I have seen often in South Florida in particular, especially among people who live in, some of the retirement communities, is that you hear a lot of chatter in the community of, I've added my children to my deed because I want to make things really easy for them. I want to make sure they avoid probate. And, without any context, it sounds like you're literally just adding your children to your deed, right? You go to the property appraiser's office, they're going to slide a form, a quick claim deed form to you and say, just put what you want here. They're not going to check it. They're not going to give you legal advice. It's 2 pages. It's cheap to file. And boom, what did you just do? You gave away your present interest in the property. You lose control over it. You made a substantial gift that you're going to need to report to the IRS. You have potentially lost all or part of your homestead exemption. You have potentially triggered
the other person having to pay taxes instead of getting an inheritance.
Right. Property taxes are going to be reassessed. So if you bought in 1999 and you did a quick claim deed in 2025, you are going to be reassessed. And then of course, again, on the recipient side, now they are going to be responsible for capital gains from the date they were added to the deed to the date they sold, instead of getting a step up in basis if they were to inherit the property at somebody's death. So that simple 2-page, and you might save yourself $500 by going into the property.
I had one. I had a seller that
and I've seen people come in and tell me, I want to take this property and put it in my trust. I become estranged from my child and I want to leave everything to somebody else. Well, is your child going to sign off on that because they own the property with you? Well, I gave it to them. Right. They own the property with you. Or the scenario, I would like to sell my property and move somewhere else, right? And then the kids who are on the deed say, no, you're not. We want you to keep that house. We're not going to sign off on that, right? So, this gift has, become a burden, and nobody wants to sue their kid, and they want to have the freedom to do what they want with their property. Okay, so that's the horror story. It happens all the time. What can you do instead? Well, there's some truth in adding your children to your deed, right? But it's done in a really careful way, and there's magic words that have to appear on the deed, and it's got to be done professionally. And so one of the ways that we can accomplish that is through a ladybird deed. And the ladybird deed allows the grantor, the current owner, to live in the property for their lifetime with the full power to do whatever they want with it. They can sell it, they can rent it out, they can let it go to waste. It's theirs. Upon their passing, it goes to what we call the remainder beneficiaries. And then maybe that's their children, maybe it's somebody else, right? Adults. And that's one way to keep the property out of probate. It's a seamless transition. It bypasses probate. The remainder beneficiaries inherit at the death of the grantor and the life tenant. They're the same person. And there's a step up in basis, right? So that is one way to do it.
Let's talk real quick about the step up in basis in a nutshell. So people out there who may not understand that off the bat, like, what does that mean? Like, where's the gold in that? Because if you don't have the step up in basis, what are they getting at? So I could kind of mention that as well. But the basis basically is going to be that the property is going to be reevaluated, like the value at the date of the passing. So why I want to bring this up as an example on my end is I had a seller at one point that had gotten their family member passed away, and they didn't go to sell the house until about 2.5 years later. And so why did that hurt them? Because when the person passed away, the property was not worth what it was worth 2.5 years later. And so one, they lost the homestead. It got shot up. It got reassessed, shot up. All that happened. And then they also got, when they were like, oh, well, what's the situation with like taxes? Like we inherited it. And I've said, listen, you'll speak to your accountant, but you inherit that basis of what the value. When you inherit that property, you get the value at the time of passing. So as a realtor, I'll be like, hey, all right, this sold for like $200,000 back on January 5th of 2022. And now it's 2025 and you're selling it for $350,000. So while you're not going to be paying taxes from the $350 to when your mom bought it for $20,000 decades ago, you're going to get that step up. And so it's going to put you at that $200,000. This is very like elementary. I'm not back of the napkin, not going into the details, but you're going to now have that tax, potential tax liability on the difference between what it was worth when they passed and what you're selling it for at that time. Holding properties too, depending on what kind of market you're in that case, when you have inherited properties, end up hurting sellers in more ways than one, because of the fact that you're going to end up having gains. Whereas if you would have sold it at that point, but then again, obviously, if you sold it at that point and it was much lower, then you made money. So just keep that in mind, that if you are selling it later at the big difference of a price later and having to pay taxes, you're going to have tax implication. If you sell it right when they pass away and you're going to your accountant with a CMA I gave you of like, all right, we sold it within a few months, the value when they pass is the same value when you sold, there's not going to have that big of a delta. But there could be potential tax implications on an inheritance once you've passed that value difference from the step.
And I think it's important to distinguish that it's not necessarily having to do with the inheritance itself. Like it's not an inheritance tax, right? It's not something that you're paying because you inherited it, but it's part of the it's part of the property, right? Like the step up in basis, like just as you described it, it kind of locks in the value as of the date of death, right? So if you sell in 6 months from now and it's gone up $100,000 in 6 months, you're going to owe capital gains on that 100,000, right? But if it was purchased back in the 60s for 5,000, like you mentioned, you're not going to owe capital gains from the 60s to 2025 when you actually sold. Unless they did that other terrible thing that I just talked about, right?
Yep.
Right. They added you to the deed and you became a present owner of the property, in which case you're on that deed from the date it was signed until the date it was sold. So doing a ladybird deed is one way to get that step up in basis, right? You don't actually become an owner as a remainder beneficiary until the date of death. So that's, in a nutshell, the step up in basis.
And then, so you have the option to do a life estate deed with ladybird language, or potentially, depending on your certain situation and speaking with a great professional like yourself, it's all about planning, right? Not every single person's story matches. It's not a one size fits all. So maybe you're in a position where you might be putting it into a trust. So speak a little bit about trusts and, real estate and, what that looks like.
Yeah, I definitely recommend trust if you have multiple pieces of real estate. If you are an investor and you own your property through a business, you may not be putting the property themselves in trust, but your business might flow through the trust in one way or another. But if you own a piece of property and you're putting it into your revocable trust, it avoids probate and you get that step up in basis, just like we talked about with the ladybird deed. Anything that's titled into a trust is going to avoid probate and it will avoid that court process that we talked about. But having said that, there are restrictions on what you can do with your homestead property. So it doesn't fit every scenario, right? If you are a parent with young children, you're not putting your homestead into trust, right?
Remember,
The
you taught
law
me that.
says, yeah, the law restricts devise of homestead when you are either married and or have minor kids. Now, the marriage part, if you're married and you're both on title and you don't have any minor kids, you can do whatever you want. You can put it into trust. A lot of practitioners will say maybe you don't want to put it into trust fully. Maybe you want a ladybird deed it to trust if you're a married couple because you already have like pretty decent protection just owning property as husband and wife and owning in particular homestead property as husband and wife. But if you own property in your name alone and you're married, or you have minor kids, you cannot just deed your property, your homestead property, into trust. It's going to require, number one, it may not be able to do it, but number two, if you don't have the minor kid situation, but you have the marriage situation, it's going to require your spouse to participate in that transfer and potentially waive some of the rights that they have under the homestead laws. So that's something that we caution people on. A lot of times people don't realize that they're married and they own a property in their name alone. They just assume that it's going to go to their spouse. But if they have children, even if those children are of that marriage, your spouse is in under the probate rules is entitled to a life estate or a life estate with the remainder to the kids. And now imagine they're your kids and they're little. You get a life estate, your kids get the remainder. Or if they timely elect it, they can get 50% with the other 50% going to the kids.
That's one on the example we have. 50% for the wife that was, and then the kids shared 50% is how it fell.
Right. Exactly. And so the homestead rules are even a little bit different than the regular intestate rules. Intestate rules kick in when somebody dies without a will. It's basically the Florida legislature writing the will for you. And then we take it up a notch for homestead because homestead is its own little carve out under the rules. And so normally if somebody dies and they're married and they have kids and all the kids are kids of the marriage, the kids are going, the entire inheritance is going to the spouse, right? However, not with homestead, right? Even if they're your kids, they're little kids and they're children of the marriage, they're going to take a piece of that homestead. So on the planning side, people may want to just add their spouse to their deed. Right? To just say, you know what? No, if something happens to me, I want my spouse to own it 100%. So that's one of the, exceptions to adding somebody to the deed that I would say, okay, that makes a lot of sense, right? To add your spouse to the deed. Not everybody wants that. Sometimes people have prenuptial agreements that, dictate how they're going to do things, but there's no avoiding the homestead probate rules when you are married and have minor kids.
Awesome. Thanks. Sorry. So there are different types of probates, right? So you were saying sometimes it's quick, sometimes easy. What are summary administration? What does that look like as opposed to, doing the full thing? Speak a little bit about what different types of probate situations you can find yourself in and kind of how long they can run and what type of considerations are involved in both of those.
So the two primary that I would be involved in, because that you would need an attorney for, summary administration or formal administration. A summary administration is a simplified proceeding. You're entitled to it if the assets of the estate are valued at less than $75,000, or the decedent has been deceased for more than 2 years. Under a summary administration, you're not seeking the appointment of a personal representative. There is no representative of the estate. You're essentially telling the court, Judge, we know exactly what the assets are. They fit the criteria. We know exactly who the heirs or the beneficiaries are. This is who they are. And we just need you to issue an order distributing under the rules or under the will, right? And we really, at least in my practice, I only do a summary administration if I'm sure the client is sure there are no creditors. If there are creditors out there, a summary administration likely going to end up turning into a formal, and you might as well just start with a formal and not have to draft the paperwork twice. But if you have a perfect situation, the decedent's been dead more than 2 years and everybody's on board, we know exactly what the property is and we know exactly who's getting it, summary administration, you open it and you close it. You file the petition, you file the death certificate and or the original will, and you get your order, and that order distributes the property directly to the heirs or the beneficiaries. We see it a lot for homestead. But again, I typically only do it when I'm sure there's no creditors, right? We don't want any hiccups, in that process. With homestead, whether it's summary or formal, you're also filing a petition asking the court to determine that the property is homestead and deserving of creditor protection. And you have to state why, under the rules, it qualifies for that.
Quick question. Sorry to interrupt.
Yeah.
The $75,000 that you said, is that outside of the homestead's value?
Oh, yes. Good question. $75,000 is the threshold, but homestead is exempt.
Right. So I just wanted to put it out there that
homestead is
it's not that we're selling $75,000 condos and that's all they owned. So the homestead could be higher, but it's the other assets. Awesome. Yeah.
Right. And there's criteria to make sure that it qualifies as homestead. But yes, generally speaking, homestead, it's exempt. And so it qualifies basically as zero for a summary administration. Now, if you have homestead and you have an account with $76,000 in it, no summary administration. It's not going to work. You can't just open the summary and do you're going to have to do it the proper way and open it as a formal. And a formal administration is kind of what people think of when they think of a probate, right? You're going to petition the court, get somebody appointed. That person is going to notify all the interested parties, put creditors on notice, gather up, and marshal the assets, put them in an estate account, wait out the creditor period, and then once all the claims are dealt with, ask the court to distribute the assets. And that process is a much longer process. It doesn't have to take years. It can, but in most cases, you're looking at probably 6 months to a year on a formal administration. And it's really going to depend on the cooperation of the interested parties, right? If they're uncooperative, maybe they don't have anything to contest, but they're not necessarily like participating or actively participating, and you're chasing them down and they're not signing and you're having to serve them formally with legal documents, that really slows down the process. So in my practice, handling uncontested probate administration, we really try to determine from the outset what the family dynamic is and how people get along so that we can give a proper estimate on, what to expect, with the timeline. With a formal administration, there's a mandatory 3-month period where you're not distributing assets. It's strictly for claims to come in. And so during that period, the personal representative can be productive by marshaling the assets, getting the house ready to sell, getting all their ducks in a row so that when the creditor period ends, they can quickly move and execute on a real estate transaction. But for the most part, you're not getting a distribution during the creditor period. We can petition for it. I have petitioned for it and asked the court, to allow us to sell property during the creditor period if we hold back the funds in escrow until the creditor period expires. But every time I have done that, we have put in so much effort to try to rush it through. By the time it actually sells, you're pretty much at the end of the creditor period anyway. Mm-hmm. And then in that case, once you get your order distributing the property, order determining homestead, if it's a homestead property, your sellers become the heirs, right? It's no longer an estate asset. So my preference is to let the probate unfold the way it's supposed to, go through the creditor period, and then once that ends, get yourself set up for a sale. And then once the creditor period ends, move forward with your sellers.
Awesome. Yeah. Is there anything that can happen that makes things like even more difficult? So some things that come to mind, you have heirs and people who are now someone passes away and you're dealing with figuring out who the heirs are, right? And so one person might be the one that opens the probate with you, and then we're trying to figure out cousins and uncles and cousins and people, and how does that all shake out? Because where do you find people? How do you figure out that everyone's an heir who's supposed to be an heir? Like, how do you kind of, where does the court say, all right, we believe you, we're good, we got everybody, this is who's who? How does that look? And I know we've done some serious ones that involved a lot of info digging.
Yeah. I mean, I could talk about this for a really long time because a lot of times people come to us. The biggest problem is multiple deaths in a family. I would say years of neglecting to probate an asset, thinking that the probate issue is going to go away. It's not. It's part of it's a title issue that needs to be cleared.
And sometimes
You
it's not
can't
even neglect,
stop.
Nicole. Sometimes, a lot of times people come and they were like, what does that mean? What do you mean? The deed says my dad's name on it. He got it from someone else. And like, we didn't know, right? So a lot of times it's not even like anyone out there is listening. You may not know, right? You may not have known about this. And so that's why getting educated is important. But it's not necessarily always like neglect. But yeah, sometimes it is. You don't think about it, or you're like, oh, she told me it was going to cost X amount of money. We don't have that money. We can't do it. We're just going to hang out. And that's the generational homes that I call them, my generational homes. When they say, oh, it's been in my family for years. Let me tell you right now, all of my listings that have been in families for years have been disastrous. Like, that's my flag. I have a checklist in my listing prep that says, was this a generational home? Do some more digging.
Yeah.
Because they've been
And
a mess.
Yeah, that's exactly it. Like, culturally, you have families that will stick together, right? They live together. They live together with their children and their grandparents, the parents. And when somebody passes away, life continues on in that household, right? And then somebody else passes away and life continues on in the household. So we do have these like generational homes where there's multiple deaths in the family. And what I find in my practice is people don't understand that dead people have an interest in an estate. So when you ask somebody, who are the interested parties? Who are the heirs? They just list the people they know that are still alive. And so as a probate attorney, you really have to, get that family tree organized, because the court is going to ask your client to complete uh, an affidavit of heirs, and to sign that, indicating, um, that you have given all the information that you have. And if you don't have enough information, the court may not accept that. So if you are not sure if somebody was married or not, that's going to be a big red flag, right?
Mm-hmm.
Because somebody who's married, their spouse absolutely has inheritance rights. So those are the kinds of things that, the client's going to have to come up with that information. Now, if they're like, we don't know, and, we need help, then there are things that we can do. We can, hire an investigator to come up with a report. We can hire an heir search company to do a more thorough investigation, to find heirs. I've had many cases in my career where the people who inherited the estate didn't even know the decedent, right? We found them because we didn't have anybody. We weren't able to locate a family member. I've had people come to me and say, this is my family member. This is our family's property. We grew up together. It's just us. We file the probate. They fill out the affidavit, truthfully, their truth.
Right.
Come to find out, another company came in, found lost heirs on the other side of the family, and now they're inheriting half of the family real estate, in the Midwest, right? And it happens. So, deaths in the family, like, just because somebody passes away doesn't mean that it's going to eliminate their share in the property. Another thing that has come up are when people do like a DIY trust or will, right? I had a family come to me and they say, our mom left us this property in her trust. Why can't we sell it? And come to find out, the property wasn't actually titled to the trust.
Yep.
Right? The trust existed, but it had nothing in it. And so what happens, if it's not actually in the trust, the Florida default rules kick in, right? Unless there's a will. But of course, on this DIY kit, there was only a trust and no will because people don't know you should have both. If you have a trust, you're going to have a will as a backup plan. And so the default rules kicked in. And what happened is their parent had a child who predeceased. That child had a child. That child became an owner. So they had to now buy out their younger niece or nephew or whatever the familial link was in order to get that property that ultimately their parent wanted to go to them, right? So we see that too, where, people just don't know what they don't know. And they think that they have, put a plan in place. And again, that is not going to be analyzed until it's too late.
Yeah. I think one of the first probate cases we did a long time ago, like right when the pandemic hit, I feel like I was changing the lock to the door, like with a mask, and I had to get the mask. It was like the last, and the heir said, my mom was so smart. She was a very brilliant woman. And she said she did everything right. We're all good. She went to an attorney and got everything set up. And I was like, okay, great. So I'm looking at the house right now, and the house is in her name only. And they're like, no, she put it in the trust. Meanwhile, like there wasn't a trust, there was a will. And that was it. And I'm like, we're going to have to do probate. And they're like, no, my mom would never have done that. She went to the attorney. It was a elder law attorney, estate planning attorney. And they didn't do that. And I've had a lot of situations where it's gotten to that point. So it makes me wonder, like, why? Is it something that maybe the attorney had given them a cost and they just said, no, we can't do it. We're not going to do it. Let's just do the basic, or let's just do this, or let's forget about it. I don't know what it is, but I feel like, as professionals, you guys probably are giving that advice, and maybe the end user didn't heed it because they didn't want to spend $600, $800, $1,000, $2,000, $3,000, whatever it was. And they just were like, just write me the will, great, I'm good.
Yeah.
So to the listeners out there, heed the advice. Make sure you've got yourself bulletproofed, because it comes back to bite you.
Right. And I am, never quick to judge a practitioner on the work that they did, because I know that, ultimately, you make recommendations and the clients make decisions. But I will say, in my practice, I have made a point to say, like, I don't want to do like a one-off, document. That's not what I offer. I offer comprehensive planning, and so those are packages and these are recommendations that I make. And if somebody does choose, let's say, not to do a deed because, or for whatever reason, right? They just they don't want to do it. That goes in my notes. We recommended a package with a deed.
Yeah.
We talked about the pros and the cons, and we made this recommendation, and the client declined, right? Maybe it comes down to cost. Maybe there's some other, I've had people tell me, oh, I'm a realtor. I have somebody who can do a deed for me. Okay. You don't want me to do the deed? That's fine. You can do it. And then maybe they never get it done. Maybe they do. I don't know. They've made that call. So, yeah, that happens. You just never know what somebody says. I had a client who I had told for many years in her planning that she needed a trust. She had a substantial business with and there's a lot of money in the business. And I said, this is definitely going to be a costly probate. And she didn't want to pay for the trust. She wanted a will. She was very, clear about her wishes. I met with her more than once. I did her plan and updated her plan more than once. And it did end up going through probate, and so that was clearly documented in my file that, the recommendation was made and client declined.
The one thing I like to tell people, the importance about doing all this stuff correctly and planning and, realizing that it costs some money, you got to get it done. When you pass away and you are leaving your children and they are now mourning you, they're cleaning out your house, they're, really, they should be focused on that healing process. They should be focused on, putting you to rest and figuring out how to heal and move on and working and being together as a family and doing all that stuff, right? Through my years of doing this, probate is not pretty. So if if you want to take care of your children and make sure that you are being remembered, and when you pass away, that you're able to pass away, they're able to move on comfortably, and life is good and everything's good. But if you don't do the right things, you're putting them in a position where I've dealt with it. I've gotten yelled at. I've gotten screamed at. I have people who hate each other. By the end of it, they're fighting, arguing, money, things like that. Do your legacy a favor and make sure your ducks are in a row, because probate is costly. It's also very, it adds extra stress, and it just kind of makes things a lot more difficult than they have to be. And I see it just because I like to look at the psych side of it. Like, people shouldn't have to do that, right? Like, they should have to be able to move on and mourn you and remember you and not have to go through the process of, 7 to 12 heirs on a property. And then it just kind of taints it, in my opinion, right? It just kind of makes... There's no reason it had to be that way, right? So just, if anything I could say from my years of experience of doing this, and I'm sure you can agree, like, the planning is everything. Get with the right professionals. Make sure that your situation is ironclad and that there's no issues, so that your heirs, your children, can be comfortable and not have to deal with any extra stress. Because yes, you're not going to be here. Great. It's wonderful. But I wouldn't want my family to have to deal with the nonsense that comes after it. And also, too, keep in mind, probate has a cost, right? So to be able to start that, you may be leaving a property to a child that does not have money. And for them to actually do that probate process, they have to be able to start and pay an attorney and come out of pocket. And, that's not readily... It's not pro bono. It's not coming out free. So it becomes a hassle. And I've seen over the years where people haven't done the probates because they didn't have that money. And then later, not only do they have one person that passed, now they got a history of people that have passed over the last 20 years because they didn't do that. And then you have a bigger mess. So if I could stress anything, is the planning and doing that right.
As a realtor and I know as a probate attorney that the risk of taking a case based on a future sale is really high, right? Because they could back out. And so it's not, mean to say we need to be paid up front for this work. Like, we can get title in your name, but it's going to cost money to do that, right? Where we have cases tied to a sale that we have no control over,
Right.
that becomes a very risky business decision. So, have I done it? Yes.
I'm a good person. We have hearts where, servant people. But is everyone going to? No. I mean, I spoke to an attorney on one of the cases we did, and I was like, let's keep this in mind. This is what this attorney did. Would you have done that? And they're like, no, I don't think I would have. And I'm like, exactly. Keep that in mind. Planning.
Yeah, well,
it's all about planning.
You have a Capricorn realtor and Capricorn attorney working together. Monster probate case. That's going to get finished.
Yes, no, for sure. Listen, we go to the death. We're like, listen, we're going to get this done. We're both the workhorses, and nothing scares us. And then at some point, it becomes just like a project of just like, what do you call it? You just have to get it done because it's just a principle, right?
It's a pet project,
pet
right?
Project,
it's like,
exactly.
No, I'm going to finish this. Yeah, absolutely.
And then another fill in your belt.
Exactly. And that's part of the thing. I love this work. Yes, there are challenges when you have family members that are not getting along and things like that. And nobody wants to deal with that stressful dynamic in an already stressful situation. But in my practice, for the most part, I'm dealing with very kind people that need help getting through the process. And it's very rewarding to do that work, right? Because they're hiring you, there's something in the end for them. And there's a lot of people they can choose, but they picked you because they knew you had a reputation for it, that you could get it done, that it would be efficient, that you're not going to start a case in 2022 and have it lingering on unfinished in 2025 or 2026, right? So for me, the work is really rewarding work, and picking the right clients to work with, it makes all the difference in the world. But probate is something that, people don't choose. They're thrown into this. Um, and you mentioned it that, the stress of it, hiring the probate attorney is one of the stressors, right? But once you hire them, the legal burden shifts from you to them, right? We take that on, right? Just like when somebody hires you to do the sale, you take that on, right? And you shift, the burden shifts to you. But what doesn't shift is the practical boots on the ground work that needs to be done, right? Somebody needs to clean up. Somebody needs to go to the bank. Somebody needs to open up the mail. Those practical things. So like the probate is an added stress. If you can avoid it, it makes your family's life so much easier. But you have to note that it's not the only stressor, right? There's other things that need to be done that only somebody in your family can handle that, right?
Awesome. Nicole, thank you. As always, you are a wealth of information. I love chatting with you. So let the listeners out there know how they can find you. Maybe your website, or I guess your website or office number. If you guys ever need anything in the world of probate or estate planning, hopefully estate planning before probate, give Nicole a shout. Let them know where they can reach you.
Yes. So for agents, I'm an open resource, right? I'm always happy to answer questions and just make you feel more comfortable about a transaction that you're working on. No strings attached. I just want everybody to know what they're doing, and I'm very passionate about probate. But yes, planning. We want to plan. We want to plan to avoid probate. If you're in probate and you need a probate attorney, I'm happy to help. My office number is 561-921-5751. And my website is LoughlinLawPA.com, on socials at LoughlinLawPA. It's LOUGHLINLAWPA.
Awesome. Well, thank you so much again. I always love, there's certain topics that really call me, and this is one of them. So we had a long show today, which is great. So everyone out there, if you got some golden nuggets from this, if you feel like you've gotten some value, please share it with family members. I'm all about pushing, like Nicole said, all about making sure that everyone knows, that gets the education that they need. That is my goal. So please share it with family, share it with friends, like the show, give us reviews. I appreciate you listening, and I hope you were able to get something really good out of today's episode. And I like to say this as well, sometimes you hear things and then you put it in your back pocket, you don't follow up, put it in your notes, make it a point to, take something and go with it this year before you forget, because life gets busy and we get that. And then you get kind of falling into something. So make that promise to yourself to take care of something that you may have learned from today. And thank you guys for listening. I really appreciate you being here, and I look forward to seeing you on the next one. Have a great day.
Ladies and gentlemen, welcome aboard Air France Business Cabin. Here, every detail matters in elevating your journey. From priority access to your arrival, to menus created by Michelin star chefs, high-speed Wi-Fi powered by Starlink, or mattress topper designed by a leading luxury hotel. Thoughtful touches in the air and on the ground, all crafted with your well-being in mind. Air France Business Cabin, the art of travel elevated. Elegance is a journey. Air France. See conditions at airfrance.us.